Hi everyone. Our group presentation is on language instruction policy. I am Daisy and my group is Wei, Qingli, and Jay. The following is content we will be learning about propositions, amendments, and Supreme Court cases. Some of the learning objectives is to learn about different court cases that impacted the transformation of language policy in schools, and learn about the propositions and initiatives that impacted bilingual education. The Amendment Bilingual Education Act, also known as the Title VII of the Elementary and Secondary Act of 1967, was the first federal legislation and intervention that recognized the needs of limited English speaking ability students. And it was introduced by the Texas Senator Ralph and was signed by President Johnson on January 2nd of 1968. And it was intended to help language minority students in schools. The purpose was to provide school districts with federal funds in the form of grants and establish these educational programs for students with limited English speaking ability, which was the beginning of something huge for students who needed the support. The administration of Johnson was able to address the poverty and education gap the students were experiencing. Programs like Head Start and Title I at-risk students were some of the programs initiated under this law. The Chacon-Mascon Bilingual Bicultural Education Act was passed in 1976. Some background information: Assemblyman Peter Chacon, recognized today as the father of bilingual education in California, along with Senator George Mascon, joined forces together to push for this assembly bill. And what this piece of legislation did, it was replaced with the AB 2284 in 1972, was the first act that mandated school districts to provide language minority students with equal educational opportunities, that despite their limited proficiency in English, they were able to provide these resources for them. So this bill calls for flexible programs and financial support, specifically for schools to implement these programs at their sites, like basic bilingual education programs and bilingual bicultural education programs to teach two languages and for students to achieve proficiency in both languages, in addition to learning and understanding the culture and history behind the languages. I want to begin by briefly mentioning a court case, Lee versus Johnson. Why was it important? Because it was the foundation of the desegregation of schools in San Francisco. So this specific Supreme Court case is Lau versus Nichols. Before we get into the bigger details, I want to introduce some background information of the case. So the plaintiff is the student Lau, and the defendant is the SFUSD, San Francisco School District. The respondent of the school district is Alan Nichols. And the ruling in favor of Lau was in January 21st of 1974. In this slide, we're going to read and learn about a key factor of why the suit came to be. The background of the case: the San Francisco Unified School District population was made of Chinese ancestry. Approximately 2,900 were non-English speakers attending the school, and of that population, only 1,000 students were provided support in English learning, while the rest were not. So how the lawsuit came to be was a public lawyer, Edward Steinman, reached out to the parents of the student Kenny Lau and other Chinese students with limited English proficiency. And they were claiming that students were not receiving help due to their inability to speak English, violating the 14th Amendment, which prohibits discrimination based on race, color, or national origin in any program or activity receiving federal financial assistance. But the court denied the relief, and the court of appeals affirmed. It said that they had not violated the 14th Amendment because all students were still receiving the same education available to other students in the school. The district argued that the school didn't intentionally mean to discriminate against students with limited English proficiency, and that the uniform policy was to provide education to all students, and that's what they were receiving. Also, the school was expressing that they were not accountable for where the students were at academically with their language. So the students in Lao appealed, and the court relieved, showing that the school was federally funded. Um, Therefore, they were required to provide equal opportunities and access to all students. So the court then focused on Section 601 of the Civil Rights Act, which was violating the Equal Protection Clause in Section 6 of the Civil Rights Act. After the ruling, the Supreme Court demanded that the school district needed to make changes to provide equal education for the non-English speakers. In this slide, you can view a summary and informative video of the case Lau versus Nichols. In relation to the rating, it explains how the Equal Protection Clause requires the government to treat people who are similarly situated the same, concluding that students under this law were protected and needed to be provided with resources and supporting programs to succeed in school and the classroom, no matter their language proficiency in English.
Hi guys, our group topic is language instruction policy, and my part is Castaneda versus Picard and California Assembly Bill 507. The case of Castaneda versus Picard was first tried in the United States District Court for the Southern District of Texas in 1978. The case was a fight against Raymondville Independent School District in Texas by Roy Castaneda, the father of two Mexican-American children. Mr. Castaneda claimed that the RSD was discriminating against his children because of their ethnicity. The district court ruled in favor of RSD based on its determination that the policy and the practice of RSD did not violate any constitutional rights of the plaintiff car. Apparently, Mr. Castaneda was not happy about the results, so they filed appeal to the United States Court of Appeals, arguing that the district court made a mistake in its ruling. Specifically, a plaintiff charged that the school district unlawfully discriminated against them by using an ability grouping system for classroom assignment, which was based on racially discriminatory criteria. Also, they alleged that the RSD deprived them of the rights secured by the 14th Amendment, Title VI of the Civil Rights Act of 1964 and Equal Educational Opportunity Act of 1974. So in order to know what is going on there, we need to know what is the act about. The act mandates that the educational agency to take appropriate action to overcome language barriers that impede equal participation by its students. So the court, in this case, the court had three challenges. The first one is that the Act EEOA did not define the term appropriate action. So it does not define what is required to state a claim. Congress provided little guidance to interpret the term, and there was little legislative record there. So the court have to look to the plain meaning of the code itself and the historical context in which the act originated. So based on the reasoning, the court adopt a three-part test to determine whether the school district are providing appropriate action which overcome language barriers in the program. The first one is theory. It requires that the program must be based on a sound educational theory. And practice, this is talking about the program must be implemented effectively with adequate resources and personnel. And the final one, it requires that the program, after a trial period, the program must be evaluated as effective in overcoming language handicaps. If we visualize it in a pie chart, it looks like this. So the three parts work together to determine the adequacy of a program for ELLs. So we may want to ask, is the three-part task powerful enough to force the school to address language barrier? So here we have some shortcomings of the test. In terms of the theory, nearly any program can be justified by an educational theory. As long as the school has an education theory with the backing of at least one expert, the theory will be deemed sound. And the second part, practice. The practice part looks at whether school have used adequate practice and personnel to effectively implement the program. However, if school failed to recruit adequate staff, it is excusable. And third and final one, requires the court to determine whether the program is effective. However, the Castaneda test provides no guidance in determining what standard a court should use in evaluating an educational program. So it's hard to define what result should be deemed sufficient. And because a trial period could take years, so the student may be harmed already before an inadequate program are identified and rectified. And I want to go deeper about the ability grouping because it's a controversial strategy, and we will discuss it when we have a Zoom meeting. In RSD, students are placed in a particular ability group labeled as high, average, and low based on the 4 factors. The court think the ability grouping system is not per se unconstitutional as long as it is motivated by educational concern and not by discriminatory motives. If we take a look at the statistical result of ability grouping in grades K-3, Anglo students form approximately 17% of the student population at the Central Elementary campus. However, 41% of the students in high ability classes were Anglo. The record also suggests that the primary ability assessed by the district is English language proficiency. The ability group for the 1st to 3rd grade are determined by 3 factors. One of them is scores on standardized achievement tests. However, these tests are administered in English, so the test cannot be expected to accurately assess the ability of a student who has a limited language skill. Therefore, the ability group practice in remote developed school district has segregated effect for students. And I post a link of the video in the reference page if you're interested. In California, the Assembly Bill 507, also known as Bilingual Education Improvement and Reform Act, was designed to update and strengthen Assembly Bill 1329, also known as the Moscone Bilingual Bicultural Education Act. My teammate Daisy just talked about this act. So like Assembly Bill 1329, the Assembly Bill 507 mandate that school district provide bilingual instruction for every LEP student in California. It strengthened the formal act in several ways, including expanding the use of student primary language in classroom instruction. So if you are confusing about the chronological order of the act, I have a timeline here. In order to comply with the current requirement of state law regarding bilingual education, California school district must implement 7 strategies in order to comply with 2 federal guarantees to protect educational rights of LEP students. The goal includes develop student proficiency in English, provide positive reinforcement of the self-image, promote cross-cultural understanding, and provide equal opportunity for academic achievement. And the 2 guarantees includes equal educational opportunity and participation. In order to implement this goal, the current law specifies three primary strategies and four secondary strategies. The secondary strategy further specifies the requirements of staff, parent, and plans and fundings of the program. At the elementary level, whenever there are 10 or more LEP students with the same primary language at the same grade level, the school must establish a program with options specified by the SDE. So the options are outlined below. You can see there are basic bilingual program, bilingual bicultural program, and etc. So in conclusion, under Assembly Bill 507, the California Department of Education has continued to uphold the bill's principles, and school districts are still required to identify LEP students and provide them with English language development, core curriculum, and cross-culture and self-concept instruction delivered by qualified teachers.
California Proposition 63. It declared that English is the official language of the state of California to preserve the role of English as the state's common language. It also prohibits the legislature from passing law which diminish or ignore the role of English as the state's common language. People has different opinions about this proposition. People who voted for a yes, they believe that as more and more immigrants came from southern-born and Asia, English as a language was threatened. Making English the official language in California is a way to preserve the language. Learning English would also promote assimilation to the majority culture. And this proposition would strongly encourage immigrants to learn English. However, another group, they voted no. They believe this proposition was highly likely to result in unnecessary lawsuits. And the proposition has a lot of uncertainties. It was vague. People, they don't know if it would attack in bilingual educational programs and bilingual services. The result of Proposition 63, it was extremely popular, passing by a margin of 73% to 27%. You can see the data over here, and the status is approved. Some impacts of Proposition 63 between 1987 and 1995, similar proposals were put forth. 11 states passed these proposals. It brought the total of official English states to 20. Teresa P. versus Berkeley Unified School District. The plaintiffs are all LEP students enrolled in Berkeley's Unified School District (BUSD). Defendants are the Board of Education of BUSD. LEP students in BUSD as of June 15, 1988, 571 students, around 7% of the total student body, were LEP students. They represent 38 different language groups and are enrolled in 16 different schools. Plaintiffs sued the school district because they have been denied equal educational opportunity. The district has failed to take appropriate action to overcome language barriers faced by plaintiffs. The BUSD testing and procedure for the identification and assessment of LEP students are inadequate. and that the district employs inappropriate criteria and procedure to determine when the district programs of special language service for individual LEP students are no longer necessary or appropriate. BUSD also has failed to allocate adequate resources to the district's special language service for LEP students and has failed to assure the teachers and other instructional personnel has the qualification, credentials, and skills to provide the service effectively. Finally, they contend that the school district has not provided them with adequate English language development instruction and adequate native tongue instruction and support. In order to help LEP students to develop fluency in English and to provide academic support to LEP students while students learn English, special language service were provided in BUSD. The district has two types of special language service. One is special language program. The other one is ESL program in three separate forms. The school district's classroom teachers have received training and workshops to improve themselves on educational strategy designed for effective teaching of LEP students. The result of this case, due to Berkeley limited financial resources, Judge Jensen said, it is highly unlikely that the district could fill all necessary positions with fully credentialed teachers. He also rejected the charge that the district used inadequate procedure to identify LEP students and to ensure their readiness to exit bilingual classroom. Therefore, this court entered judgment in favor of defendants.
Hi, I am Jay. I will demonstrate two propositions to you guys for my part. California 227 and California Education for Global Economy Initiative, also called Proposition 58. From 1996 to 1997, California's public schools serve 5.6 million students in K through 12. During these 2 years, schools identified 1.4 million, or 25% of the students as limited English proficient (LEP). These are students who cannot understand English well enough to keep up in school. Next, here is a timeline of this proposition. Proposition 227 was a California ballot proposition passed on June 2nd, 1998. And the proposition was controversial because of its close relation to heated political issues, including race, immigration, and poverty. On September 28, 2014, the state passed the proposition, and Governor Jerry Brown signed a bill, which added Proposition 58 to a November 2016 ballot. Okay, and on November 8, 2013, Proposition 227 was repealed by Proposition 58. Under the proposition, schools must make their lessons understandable to LEP students to help schools address the needs of these students. The State Department of Education had guidelines for the development of local LEP programs. Okay, first, the primary purpose of all programmer is to ensure that LEP students are fluent in English, and the programs must make it easier for LEP students to perform well in all schoolwork. In some cases, this means that certain subjects are taught to LEP students in their home languages. Schools must enable all LEP students to engage in bilingual programs. The bilingual program is one where the students are taught both in their home language and in English. And last, school must allow parents to evaluate whether their children are in bilingual programs or not. And next is how are students served? School choose a range of services to help LEP students in two ways. One, learn how to speak, read, and write English, and two, learn academic subjects such as math, reading, writing, history, and science. Surveys to help students learn English. Almost all LEP students are provided with special services to help them learn English. Such programs are also delivered during part of the school day, apart from lessons on standard academic subjects. And services to help students learn academic subjects. Around 15% of all LEP students are taught their academic subjects English with special materials. However, class materials and teaching techniques for those students are intended for students who do not speak English well. And here are two questions commonly be asked. First, how long do students receive LEP services? The answer is, in general, the students must demonstrate that they can read, write, and understand English as well as average English speakers in their grade, and they can participate equally with the fluent speakers in their classroom. A second question is, how are LEP services funded? Well, in fact, the state offers more than $400 million in special grants for students, both LEP and non-LEP, so who require more assistance to succeed in education. This one is a quote. According to Ballotpedia, Proposition 227 changed the way that limited English proficient students are taught in California. In specific, California public schools are required to teach LEP students in special classes that are taught almost all in English. This provision had an effect on eliminating the bilingual classes in most cases. It also shortened the duration when much of the LEP students spent in special classes, and it replaced most grammar programs in the state that have offered multi-year special classes to LEP students by allowing LEP students to transfer from special classes to standard classes after they have gained strong working knowledge of English, and these special classes do not usually last more than 1 year. Last, it also enabled the state government to include $50 million per year for 10 years of English classes for adults who have committed to teach LEP students. Okay, let's move forward to a newly passed proposition. California Education for a Global Economy Initiative, also known as Proposition 58. Okay, here is a recap for the Proposition 227. Okay, next. Okay, the Proposition 58 was passed on the November 8, 2016 with a merge of 74% to 26%. Okay. So under Proposition 58, the public school system have the right to choose the way they see as appropriate for their students to English. Students have the option to be taught in an English-only environment or a bilingual environment where a person of the student's native language teaches them English. This also allows English-speaking students to learn in another language. Also, the purpose of this demonstrate is to ensure that all children in California public school obtain high quality instruction, learn the English language, and have exposure to high quantity creative and search-based language services that enable them to engage competently in the global economy. And the legislation authorized the school district and the county education officials to set up language acquisition programs for both native and non-native English speakers, and allows the school districts and county education agencies to share information from parents and the community to a community in designing language acquisition programs. Okay, here is our group's presentation. Thank you for your patience.